Hey, everybody, welcome to the True Crime Squad. I'm Officer Brower here with my sister, co-host, and partner in crime, Inmate Boone. How you doing, Inmate Boone?
Well, I'd like to speak to the manager right now.
Hi,
I'd like to speak to every
guys.
manager, in fact.
Yeah, I think that you would.
Mm-hmm.
We decided just to get back to our regular schedule. We're working on the YouTube situation,
Mm-hmm.
and we're also working on how we're going to handle trials going forward. We got a lot of stuff to work on, but in the meantime, friends, true crime just keeps true criming. And
It does.
y'all may have seen in our Discord that the brilliant Jedi Jess, who we appreciate so much,
Mm-hmm.
has posted. Um, she's posted some jail notes
Mm-hmm.
about Sarah Boone, and we've all had a question about what must she be like at jail. Can you imagine?
We've had some dreams. Yeah.
So yeah, we have put together a couple of skits. We're going to do some more, but we're going to do two today. Of kind of everyone's like, JR, oh no, what the hell did I walk into? Reminds me of when you dressed up as Lori in yeah.
Mm-hmm.
Yeah, we did do that. So we've got a little skit for you, and we think you're gonna love it. And then actually, Sarah had an actual hearing today, and so we're gonna air that so that you can all see what's going on with her new attorney. What? But anyway,
Indeed.
let's kick this off.
In her cell, she pens with fight. Sarah's letters filled with fight. Judge, you're wrong, I must protest. I demand you fix this mess. Sarah's letters rude and bold, disrespect in every fold. From behind those prison bars, her insults reaching near and far. Every letter, every line, your decisions are out of line. Tune in, hear her rage. Sarah's letters on the stage. Every letter, every line, your decisions are out of line. Tune in, hear her rage. Sarah's letters on the stage. Every letter, every line, your decisions are out of line. Tune in, hear her rage. Sarah's letters on the stage. On the stage.
Inmate Boone, get your personal items out of that second locker.
I'm getting ready to shower.
The showers are closed, and you only get one locker. I find your things in a second locker again, and they're going in the trash.
I'm making a note of this.
You do that.
Why is it that you are always picking on me?
I don't pick on inmates, but I do expect the dorm rules to be followed.
Oh, yeah? Can I have a grievance form, please? And I need to speak to your supervisor. You don't like me because I'm different.
What do you mean, different?
Just get me your supervisor now.
A few days later.
Officer Brower, inmate F is calling me a murderer and going around yelling, I can't breathe. She is mocking my case that she knows nothing about.
Why am I just hearing about this now if it happened yesterday?
I don't know.
I will speak to inmate F about this matter.
You cannot talk to her. Just move her to another bunk right now, or I'm going to write this down too.
Well, you don't make the rules around here, so I think a better plan is to move you to a new bunk, Boone.
No. I can't believe that you would move me. I'm comfortable where I am. I'm fine. I'll just stay where I am then. That's fine.
Boone, if I hear one more word about this, you're moving.
Oh, yeah?
In her cell, she pens with spite. Sarah's letters filled with fight. Judge, you're wrong, I must protest. I demand you fix this mess. Sarah's letters rude and bold, disrespect in every fold. From behind those prison bars, her insults reaching near and far. Every letter, every line, your decisions are out of line. Tune in, hear her rage. Sarah's letters on the stage. Every letter, every line, your decisions are out of line. Tune in, hear her rage. Sarah's letters on the stage. Every letter, every line, your decisions are out of line. Tune in, hear her rage. Sarah's letters on the stage. On the stage.
It's a bop. Oh, boy.
It is a bop, and there you have it. That is where we begin, and believe me, there are several more coming because Ms. Boone gets her ass in trouble all the time.
Mhm.
Now, I will say she does get some positive marks, which is good. They're always because she's helping clean.
Ah,
You cannot believe the power struggles that are going on with her in food and her supposed food allergies. We'll get to that. Also, Sarah is constantly in trouble for talking when she's not supposed to be talking. I know that will come as a big surprise.
and trying to manipulate the jail staff.
Oh, constantly.
That doesn't
Like
sound
this,
fair.
yeah. Like that whole thing about you don't like me because I'm different.
Different how?
Different how? Also, so she thinks that she's the one that's going to control what the consequence is for someone running around calling her a murderer and yelling, I can't breathe, which is what her victim was yelling in the videos she took of her allowing him to die.
Mhm.
Yeah, so we're going to do some more because they
Okay.
are comedy gold.
They really
But
are.
I know we have a hearing to talk about, but you know the other thing we haven't done?
Hmm.
You haven't debuted the new Robert Tellis song right here
I
on the
know.
show.
I think we should, and then we'll talk a little more
Mhm.
about Sarah in court today. I do have a little
Mhm.
clip to share. We're going to share the whole thing at the end. You can watch the whole hearing. It's about 39 minutes long if you want to,
Mhm.
but we're going to share a few things about it, including her new attorney, because she has one. But
Who
let's
is
yeah,
this
let's
crazy
do.
person?
I'm going to tell you everything we know. But
Okay.
first, it's another ballad. I know I need to get more creative with song names, but it just seems like these guys all deserve their own ballad-ish.
I
So here we
mean,
go. This is the Ballad of Little Bobby.
In the city of Vegas where secrets reside, lived little Bobby Tells with nowhere to hide. An investigative eye caught him off guard, and the tale of his deeds would hit hard. But little Bobby claimed it wasn't me. I'm not a lame duck, you'll see. Little Bobby has a shiny bald head. He says an assassin did it, but his alibi's dead. I'm not crazy, Bobby would shout, but he couldn't, no he couldn't rule it out. In a shaggin' wagon with his mistress by his side, in the parking garage where shadows confide. Goofy and clumsy, some called him a fool, but Bobby wasn't playing by the usual rules. I'd like to think I wouldn't do that, he said, but whispers of guilt started to spread. Little Bobby has a shiny bald head. He says an assassin did it, but his alibi's dead. I'm not crazy, Bobby would shout, but he couldn't, no he couldn't rule it out. Prosecutor Hammer drops the hammer down. Little Bobby's face forms a helpless frown. From a mega mind to a boss baby fall. Now he's just another story behind the prison wall. Where's his vanity lips, standing tall in the mirror, but the truth in the court is crystal clear. Little Bobby has a shiny bald head. He says an assassin did it, but his alibi's dead. I'm not crazy, Bobby would shout, but he couldn't, no he couldn't rule it out. In a shaggin' wagon with his mistress by his side, in the parking garage where shadows confide. Goofy and clumsy, some called him a fool, but he couldn't, no he couldn't rule it out. In a shaggin' wagon with his mistress by his side, in the parking garage where shadows confide. Goofy and clumsy, some called him a fool, but he couldn't, no he couldn't rule it out. In a shaggin' wagon with his mistress by his side, in the parking garage where shadows confide. In the parking garage where shadows confide. Goofy and clumsy, some called him a fool, but Bobby wasn't playing by the usual rules. I'd like to think I wouldn't do that, he said. Little Bobby has a shiny bald head. He says an assassin did it, but his alibi's dead. I'm not crazy, Bobby would shout, but he couldn't, no he couldn't rule it out. Now little Bobby's story ends in regret. A life once proud, now tangled in debt. For the truth came out despite his fight. Bobby tells won't see the Vegas lights. Lame duck or not, his chapter's closed. In the ballad of Little Bobby, his story's exposed.
A masterpiece as usual, Katie.
I don't know why. When I produced it, the AI that produced it, they sang the chorus so many times. That shaggin' wagon part absolutely kills me.
It is so funny. Oh my God, I love it. I love it. I love it.
Sorry about that, little Bobby. No, I'm not. By the way, Jaewon Jung, who we've been following on Twitter, who's over, who's a reporter there, when this was over, because she was in the courtroom every day, so we relied on her
Yeah.
notes and were able to ask her a few questions when we didn't know what was going on. She's amazing. Go follow her, find her.
She's really
But
awesome.
yeah, but she when this was over, I commented, I really hope you get a juror interview. You really deserve one. And she did. And so she interviewed the foreperson. And you guys, what did he say? They had one holdout. They had asked for both computers so they could create their own side by side of him walking, which is exactly what Kristi said. That's what she thought they were doing. The thing that held them up the most was questions about whether or not that person in the car had hair. Pretty much everything that we said was, well, I hate to brag, but correct. But at any rate,
and the questions that we suggested that she ask
she asked.
are the questions she asked.
Yeah.
So, hey, that was pretty cool.
So, Jaewon, we love you, for one.
Yes.
And for two, yeah, pretty interesting what all went down there. Yeah.
Yeah, pretty
So,
cool.
yet again, good on the jury for doing their due diligence. They really, really worked hard.
Absolutely. Absolutely. And in the chat, the name you're looking for is Nicholas Rossi.
Or Nicholas Alaverdian.
Mm-hmm.
Or Arthur Knight.
So these guys are saying, well, but they're looking for the real name. Because they're saying that Sarah Boone is the female Nick Rossi. Oh, guys, she is. Just
Nick
wait
was
and
leaving on
see.
a jet plane.
There's this document is 75 pages long of jail notes, so it's gonna take us a while. But we are gonna do some more skits because there is some funny shit in there. But I have to give her credit. She gets positive points for helping clean.
Mm-hmm.
She
There's
frequently
that.
gets a consequence of spending 2 hours in a holding cell for breaking the rules and being difficult and being a pain in the ass.
She's probably like, it's worth it. Well,
Probably, yeah.
Kristi, you had told me I needed to bring a notebook in, for my
Uh
part
huh.
of my prop. And I forgot. So I was walking past Scott's desk. I'm like, hey, do you have a notebook? I need this really quick. I said, I need a notebook and a pen. So he gave me a notebook. And then he goes,
Hmm.
you're an inmate. You don't get a pen. So he didn't have a crayon. So he gave me this piece of wax. So that's what I'm playing with.
He needed one of those big wax pencil things that
That little Bobby had.
Bobby
Yeah.
Tellis was writing with in court. Oh, that's funny.
hmm Though Sarah, she does get pens because she, has written all those letters to the judge. But
She's
one of the
been penning many a thing.
she really has, and this has been one of them.
Hmm.
This was the wanted note she put out looking for an attorney, which we all laughed a lot about. Inmate seeks an attorney, looking for a prosperous challenge, ready for your close up on national television. Are you zealous with a side of keen? Show the world who you are with your original creativity, extraordinary expertise, confident ingenuity. Qualifications must include being trustworthy, honest, passion driven, open minded, exceptional problem solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency in listening, communication, understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, committed, maintain faith in the client and case in an ability to think differently, overcoming all circumstances. Epic opportunity awaits. Invest in the oppressed. Believe. That's what I
She
said.
actually asked the judge to hang that up in the break room at his office.
Mhm, mhm.
Oh my goodness.
Well, believe it or not, that honey caught a fly, and it's this guy right here.
Oh, that's
So
a real flattering picture.
I, his website. Well, the pictures on his website were about 20 years younger, I think. This is
Oh,
James Owens. So James Owens is an attorney in Milton, Florida.
okay.
And James says that he did respond to Sarah because of her wanted ad.
Oh my God.
And after a few conversations, they came to an agreement. He said they settled their differences and came to an agreement. You mean an agreement that he's going to work for you for free, Sarah? Because that's what this is. So I want to share a few things about him first. Run back to his website here. So he's been an attorney in Florida since 1986. He says he's handled over 100 trials that went all the way through, or cases that went all the way through trial. He covers claims from simple misdemeanors to serious felonies. He is well respected and seems to be well liked. His Google reviews are really interesting. His Google reviews start with two people who left him a positive review for taking Sarah's case.
Oh wow.
Mad respect for this attorney for taking on Sarah Suitcase Boone's case. That he has chosen to provide adequate defense and protect her rights to defense counsel says a lot about his integrity as an attorney. She may be unlikable, but she still deserves a fair trial. We all know she'll get one now, and ineffective assistance of counsel will be off the table for her appeal. It is a win win. Someone else said the mere fact that Attorney Owens has taken on Sarah Boone in response to her ad makes me have immense respect for his guts and tenacity. Willingness to counsel in one of the most prolifically unlikable high profile defendants in this state that this state has ever had is undoubtedly impressive. And it goes on and on. Those were the first two that actually had to do with Sarah. There's 14 more on Google. One of them is very negative. The rest of them are all 5 stars. Uh,
Good.
Everything that I've read about him and tried to find about him in the last day or two indicates that he's legit. So good.
Good. I mean, if he can stand her,
Mm-hmm.
I mean, she has tried her level best to not have an attorney.
Mm-hmm.
Whether that's what she says out loud or not, that's
Mm-hmm.
obviously obvious from her behavior.
Mm-hmm.
But
And
if he can stand her,
yeah,
great.
so they had a hearing today because she wants an extension. He says we're going to go to trial in October. I really need more time. Uh, he told the judge that they're looking at going with battered spouse defense, and he needs more time for the psychological testing and things like that that will be required for Sarah. The judge said, "We have continued this case 16 times and we will not be doing it again. You came on pro bono. You had discussions with Sarah. You clearly already understand the case. We're not continuing. So welcome
Right.
aboard, but we're not continuing." Uh,
This doesn't qualify for battered spouse at all anyway.
right.
The way that this murder was committed, this is
Hmm.
not going to qualify for battered spouse. I'm
No.
sure he knew that, but that would be a good example of why he would want to extend it,
Mhm.
but
It's what
it's
she's
not even
been
going to
pushing
qualify.
for this whole time. That's
Yeah,
the and I'm not saying there wasn't domestic violence in that relationship. It looks like there was domestic violence on both sides of that relationship.
right.
But you cannot take videos of yourself actively killing someone while you laughed and taunt them and come back and
Over
say,
many hours in which
mhm,
you could have even
save their
left the
lives.
house and called 911 if you didn't feel safe.
Mhm.
He was certainly not in a position to harm her in any way.
No, no. So that's what's up. So she's currently deeply, deeply in love. I'm going to show you a quick clip from court. This was before court started when the bailiff first brought her in. Court started like 30 minutes late. The judge had come in and kind of, petered around for a minute. He's like, "I'm actually waiting for the state, so let's take another break." And he came back, and all the while, her attorney was in the room just waiting out. And then
Hmm.
finally, she uh, was led in by a bailiff and was making all the eyes at him. So I'm very sorry about this, but this is 1 minute of Sarah Boone flirting. For those of you that are not in the that are listening, not watching, she is really making eyes at her attorney. She's making faces at him. She's laughing. He's clearly, uh, interacting with her as well. But this is wild. This cracks me up. And whoever was running the pool camera today, they need all the
Judge, I'm
raises.
James Owens, and I'm representing Sarah Boone.
Sir, good morning, pleasure.
That
Mr. Boone,
grin.
could you please state your, raise your right hand now first and go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 101077.
Good morning, everyone.
What
And
was
that's
this a few
right.
times?
That's
I was
Sarah
like,
doing the part.
oh,
There's also a moment at the very end of court when they're leading her out that she turns and looks at him. And then as they like lead her through the door, she turns her head and looks over this shoulder too to just give him one more winning smile. It is so weird.
yikes.
Now, I will be completely fair to Owens. I think that he is just trying to do what he thinks is right.
Right.
This isn't on him. She is so goddamn weird.
Yes, that's just creepy as hell, man.
Yeah.
So creepy.
Yep. Yep. Is that not the weirdest? Okay, good. I'm glad you guys are seeing it too, because I was like, are you
Oh
kidding?
no, the smiling and the thing with her lips. I was like, oh my God, is she gonna blow him a kiss? What are you doing?
Deanna said, very demure, very mindful. Very creepy.
Exactly. Very cutesy and very creepy. Danielle says she is one of those women who thinks any show of kindness is a show of desire. She is.
Mm-hmm.
And that's sad. That's sad
It
because that
is.
tells you the kind of life that she's had. I will tell you that one of the things that she got into trouble with at jail is hugging one of her attorneys.
Oh, was it? That doesn't
Hmm.
surprise me at all. Yeah.
Yeah. She
It's
is
the
the
kind of
Timu
stuff that
Jodi Arias. Yeah, she is so gross. Oh boy.
mhm. Yeah. So that's where it sits right now. She's not getting a continuance. She does have an attorney. There's supposed to be another status conference towards the end of September, unless anything else is filed that needs to be addressed. But right now, that's where things sit. There was also a letter from someone else, I believe from California, that was sent in a motion
To
that
dismiss?
to dismiss. Yeah, that is weird, but no, thank you.
Seemed like a whole
Also,
kind of Terry Ratliff kind of situation. If you know, you know.
yeah, but also Owen says that a third party, someone in another state, called him to make sure he was legit before he made a deal with Sarah.
Mm.
Not sure who that
She
person is
has
or if it was that
she
same
has a
person.
brother that has been marginally involved. Maybe it was somebody like that.
Mm, it could be. Yeah. Did we see his quote that he wasn't going to take the case after his first meeting with Sarah? Yeah, they had to come to terms with their differences, I believe he said. Yeah.
Oh, dude.
I mean,
This
should we
has
be
only just begun.
betting cash money right now about what if he's actually with her by the time this trial starts?
I mean, I don't know. I don't know that he would have time to be removed. This trial starts in a month.
Right? I mean, the judge is real heavy on the no
I
button
think
right now. He
I'm
would
pretty
probably
sure
say
he's
no.
in and he's in.
Hmm. That could
Yeah.
be. Yeah.
I think you're right, Tubbs, that she finally settled and said, okay, fine, I'll do it. Because this is her last chance at bluffing. That judge
Hmm.
says she is going to trial.
Yep.
Come hell or high water, she's going to trial.
Well, and he only has to deal with her nonsense for another month before they go to trial. So perhaps that's doable. Zan said, I know mentor lawyer has been trying to find her a lawyer. Oh, okay. Interesting. Interesting. Maybe somebody like that put poor Owens up to it. I think he is really trying to do the honorable thing. And it is great marketing on his part. You know,
It is. It's very
no one
smart.
expects anyone to win this case, but at the same time, to do the correct constitutional thing in his mind, and represent Sarah is not the wrong decision. Maybe. I
No,
don't
it
know.
isn't.
I
I
don't know.
just
I wonder
don't.
if he's already regretting his life choices or.
I mean, this is lawyer number 10.
Mhm.
8 public defenders,
Yep.
1 privately hired attorney at the beginning, and now this pro bono attorney.
Yeah.
I mean, that is not good odds, but I guess we'll see what happens.
Yeah. Her inability to function in court scared the crap out of her, Zan said. I think so too. Yeah. Miss Smarty Pants, who said she's really good at everything, I think discovered that she's not really good at lawyering.
Because she's, in fact, not a lawyer. Yeah.
Yeah. However, I honestly, I'm kind of sad, you know, just for the comedic value. But I know that's a terrible attitude to have. But
I want her to have a fair trial so that this can be friggin'
yes,
over for the
amen to
victim's
that.
family, for the community, for
Yeah.
the court system in Florida that has spent so freaking much money on this case and still hasn't even had a trial.
Yeah.
Like, this is a good thing
Yeah. Yeah.
to get it over with.
For sure. Yeah. Yeah. Owens, yeah, he's going to get a ton of exposure. This will be good for him. You almost can't screw this up at this point, really, no matter what you do.
Yeah,
Yeah.
it's true.
Yeah.
It's true.
It's going to be wild. We know this. And it is set to start, I believe, on October 7th. So we're not far from it. Yeah.
Hmm.
And we will be streaming that one.
Yes, we
So
will.
absolutely watch for that. Yeah. So that's what I've got.
Yeah. All righty. Well, I think with that, we are going to air that entire hearing
Hmm.
so that you can see what's going on with Sarah and get a look at the new attorney.
Hmm.
And I think we'll pop on right at the end and just talk to you a little bit about what we saw And that'll be it for us today.
Okay, that works for me. And thank you, Jamie. I'm glad you're here. Okay, well, let's go. Sorry about this. You're going to have to watch the flirting again for just a minute. That's how I started it. Part of me thinks, is she playing with a toddler or her attorney? It's kind of the way you look at a little kid in the grocery store. Or maybe, I don't know. And maybe you're the creeper. But we'll get the court starts in earnest here in just a second.
Judge, I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning. Pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now. First, going to go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Pastore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense. That was filed on August 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times. Haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer. But we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for battered spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I punch them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the
Morning, sir.
hearing.
Thank you. The only thing I saw in the court file, Counselor, when I was prepping last night was the motion for statement of particulars, the file on September 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed at 8:10 yesterday, but I do not have the motion for additional discovery filed at 8:34.
I don't know why the portal was not able to post that, because they were filed one right after the other.
One's in the court file, the other three aren't. They were all filed yesterday, 19.
Certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JACS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They are not here. Your motions for these various experts report that they were sent to all persons on service lists through the e-portal. But I don't know how I can address these this morning without having JACS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I filed my notice of appearance on Friday,
Yes, sir.
and I've spoken with Dr. Berkland 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berkland. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing them to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and we can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
But if he wants to come back to my office, we can do it this morning / this afternoon.
Is your office in the building?
Yes, it's in the courthouse.
Right there. Come out the front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., State, you had the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally in writing, given the lack of time we've had to prepare to make a formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and the motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing the defense. And there's a second doctor, Dr. Michael Brandon.
Spell that one for me, sir.
Dr. Michael Brandon.
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband. Shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
And?
I've tried to reach out to Mr. Brandon this weekend unsuccessfully, and my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burton. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two. as well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved in their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs since they've already said yes, but file it and we'll try to tee it up for hearing as well to see if they have any position, or it could just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Courts had the opportunity to review that motion. Any other argument or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it, but it is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement, that was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls, and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time, or may have been.
Not me.
Okay.
My predecessor was.
But I think it was almost ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim to. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take the deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Padilla has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We've tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts will be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file the notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired if the judge doesn't continue it today. He wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said it, 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brand needs more time.
All right, thank you. State, anything else?
No.
All right, thank you very much. All right, Mr. Owens, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper. a forensic psychologist. You advise that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list, disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton v. State, 220 Southern 3rd 1152 and 1176, and Bargo v. State, 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you've sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here and had the opportunity to review those. In Ramos v. State, 75 Southern 3rd, 1277, at pinpoint 1281, by the Florida 4th DCA in 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had the discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court-appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida from 2009 to 2012. You've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. In considering all the factors as set forth in terms of the state 311, 7 3rd, 185, and 10.189, 4-2nd DCA 2020, your motion for continuance is denied. Matter, this trial is still set for October 7th. We will have pre-trial the 6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County before Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covering it, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request that I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form work, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to intend to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lane on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're the originals, but I'm going to need to look at that. I went to the jail yesterday. I had to let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what they're, I assume it's being redacted. I know some of the audio in terms of clients, comments my client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State?
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations. By and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file with the court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail, including the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m., a hearing will be held, courtroom 12A, regarding defendant's review of the USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which set this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay. State?
No objection.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
Well, I've got to go buy a jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial. Whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
I'm amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Jones?
Give me 1 minute.
Sure. State, anything else?
Not at this time, Your Honor.
Madam Clerk's going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties having no other business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
Well, well, well.
The fist bump. Now watch her as she leaves. And now maybe there's someone else in the courtroom that she's making eyes at that isn't her attorney that's on the other side of him. She's staring right at his bench. See that? Now, yeah.
Mhm.
So you're leaning back, trying to catch somebody's eye. Yeah,
It's him.
Mm.
It is him.
I think so. The fist bump cracked me up. Yeah.
Yeah, that's pretty wild.
Yeah.
Well, this judge has given him nothing.
Mm-hmm. Yeah. Nothing at all.
Well, I mean, you took this gig, buddy.
Mm-hmm. And this has got to go to trial. Yeah.
Well, it does. And I mean, obviously she's been evaluated a bunch of times for battered women, for the battered women defense, and none of those attorneys continued forward with that defense. I mean, it really tells you what you need to know.
Mm-hmm.
There's no way that the way that this murder was committed, that she would ever qualify for that.
No.
This is not a in the moment, impulsive, out of fear thing. I mean, what was it, like 14 or 15 hours that he was in that suitcase? Like, come on.
Yep. It's definitely he's just trying for a Hail Mary now because he knows, But then again, give her a good defense. Give her a robust defense. We want
I
you
mean,
to.
give her the best she's
Absolutely.
got. I mean,
Yeah.
it's the same case, no matter what the attorney is, and the defense, the prosecution's evidence doesn't change, so whatever.
I mean, the prosecution only wanted what, a week for this? 2 weeks? I mean, the entire thing isn't expected to last very long at all because mostly their whole case is the videos.
The videos, yeah.
The videos of her in her police interview versus the videos of the vest cam when the police first responded. It's all there.
She took
Yeah.
during him dying. I mean, it's hideous, but yeah.
Yeah. Wild.
Well, with that, that's what we've got for you.
Yeah.
So we will be back tomorrow night at 6 p.m. Mountain for case updates, and we've got some things in the works. We're gonna revamp a few things in the midst of our YouTube appeal. We're gonna make some changes to how we're doing things to make them, I think, better for everybody.
Mm-hmm. We hope so. Yeah.
Yeah. So keep an eye out for that. Thank you for being here. You know it. We are the True Crime Squad.
Take care.